Well, we're very honored and lucky to have Professor Stephen Collis with us. And Professor Collis is a professor at the University of Texas, Austin Law School, and also is the director of the First Amendment Center there at the law school. And he's a noted speaker in areas of First Amendment and religious freedoms and religious liberties. Is a noted author, and we're very lucky to have him here. He's a highly sought after speaker. Some of you may have heard him before. He's been with us several years with the Religious Freedom Day here in Iowa, but a tremendous knowledgeable person and asset to us on issues regarding religious freedom. So I'll turn the time over to you.
Thank you, everyone. It's a pleasure to be here. I was told to use the word intimate group. It is an intimate group. What I want to focus on is the title of my talk is The Triumph and Controversy of Religious Liberty. Of course, First Amendment. Many of you may or may not know this, but if you look at a lot of First Amendment centers around the United States or programs, they often will pick the aspects of the First Amendment that they want to focus on and ignore the freedoms that they don't. So there are First Amendment centers around the United States that call themselves First Amendment centers, but really what they are freedoms of speech and press centers. They're really not interested in the religion clauses. You'll have some other places that say they're First Amendment, but really all they do is focus on the religion clauses. They completely ignore speech, press, petition, and assembly. My center explicitly focuses on all 5 freedoms of the First Amendment. We make that a high priority. Today I'll just be focusing on religious freedom, which is a critical part of the First Amendment. And 2 clauses that I think sadly do not often get discussed enough in many institutions of higher ed. So with that, I'm going to first talk about the triumph of religious freedom, and then I'll talk about the controversy of it. I think you'll find that the controversy is probably not what you're expecting, and I'll emphasize that in a little bit. So first, the triumph of religious freedom. We take it for granted in the United States, but we are the most religiously diverse country in the history of humanity, and even really in the world today, and yet somehow we live alongside one another in relative peace. That is an extraordinary triumph that we don't really appreciate because we're living it, right? You tend to take these things for granted, but if you look back historically at world history, most religiously diverse cultures at some point or another ended up in some kind of warfare. And that's even true in the world today. So many of you may know this, but if you take, if the United States government labels something a genocide, I don't mean the way genocide is often thrown around in popular usage, but if the United States government declares something as a genocide, that triggers all sorts of treaty obligations. So the US government has to be very careful about what they call a genocide. All of the genocides right now that the United States government has declared to be genocides are actually driven by religion, not by race or ethnicity or something else. They're based on religion. And you can see this is a real problem around the world, and yet somehow in the United States, we have managed to live alongside one another despite our religious diversity. Well, how do we pull that off? There's basically 2 ways we did it. First off, philosophically, we decided we were going to protect the free exercise of religion to some degree. That means government would be limited to some degree in how much it could prevent people from living out or exercising their religion. And we have lots of different ways of thinking about this. The law is a convoluted mess. It's not my fault. I blame Congress and the Supreme Court. But it really is a huge mess. And to think about it the most simple way, though, we protect the free exercise of religion in the United States to a degree. That protection for the free exercise of religion is limited, so people they don't have absolute protection in living out their religion. And usually the test we apply is what lawyers call the compelling interest test. If government's going to burden someone's exercise of religion, government usually has to prove that it is trying to achieve a compelling interest and that it's taking the most narrow means possible to achieve that interest. That's generally how we protect the free exercise of religion. So to think about what that means for a second, government might be able to say, I'll just give you a case that I've worked on. This case was litigated for 8 years. It went up to the US Supreme Court, back down to a state trial court in Minnesota, then back up to the Minnesota Supreme Court. And I'll tell you how it ended after I tell you about the case. In that case, the Amish in a little county in Minnesota they didn't want to use septic tanks as part of their plumbing system in their homes and on their properties. And the county in which they live, Fillmore County, with backing from the state of Minnesota, mandated that everyone had to use septic tanks. Well, the Amish, they have a religious tradition that says they will not adopt new technology unless, and I should say this is not, what I'm about to say is not true for all Amish groups, but for this particular Amish group, their religious tradition was they would not adopt new technology if it would change their spiritual way of life. So for me, I used to think that all Amish groups like picked a date and time, and there was something in their religion that said any technology after that date and time would violate their religion. But that's not what they've done. What the Amish have done is said, every time a new technology comes, all of the adults over the age of 18 have to agree that this new technology is not going to change their spiritual way of life. And if they think the new technology will change their spiritual way of life, they won't adopt it. In fact, if even one person over the age of 18 says, this new technology is going to change our spiritual way of life, they won't adopt it. So when you go visit our clients in Amish country in Minnesota, you might pull up to a house that has a horse and a buggy, but then it'll have like really modern insulation on the side of the house. And people struggle to kind of figure that out, but you can see why. They've decided that the insulation doesn't change their spiritual way of life, right? Well, just to flesh this out a little bit more, the Amish, this particular Amish group, when battery-powered flashlights came along, they agreed that the battery-powered flashlights weren't going to change their spiritual way of life, transitioning from lanterns to battery-powered flashlights. So they went ahead and made that shift. So they'll use battery-powered flashlights. A few years after that, when people invented the head strap flashlights that you might use, they had another vote. And at that point, most of the women in the Amish group said, we think this will change our spiritual way of life, because right now, children as young as 2 years old go out at night and they help with the work at night. When someone's out there shoveling or they're doing really hard work, the children can be out there holding a flashlight, just like they could hold a lantern, right? But if we allow these headlamps to come in, these children are no longer going to have anything to do. They're going to not be part of kind of the hard work that it takes to live here, and they're just going to be off goofing around or playing. So we think that's going to change their spiritual way of life. They're going to lose that sense of duty. So they adopted the use of battery-powered flashlights and rejected the use of headlamps, right? You can get that sense. Well, Fillmore County came along and said, everybody has to use septic tanks to clean their gray water. Gray water is like your non-poop water, basically, right? Your non-fecal matter water. So washing your hands, showering, doing the dishes, that kind of stuff is your gray water. Fillmore County mandated everyone had to use these septic tanks. The Amish came along and voted. They decided that they did not want to have septic tanks used for that it would change their spiritual way of life because it would change all the plumbing and everything in their house, and soon that would change a lot of how they live their lives. So they voted against it. Fillmore County came back and said, hey, we have a compelling interest in ensuring that the water table does not get polluted. We're trying to ensure that the water table does not get polluted. That's our compelling interest. So you have to use septic tanks. Now remember what I said though about how we protect the free exercise of religion. There's two parts of this test. Government has to show it has a compelling interest, and government has to show it's taken the most narrow means possible to achieve that interest. In that case, the question wasn't really about, does government have a compelling interest in ensuring the water table doesn't get polluted? Everybody agreed that's a compelling interest. The question was there a way to accommodate the Amish that would allow them to still live their religion and allow the government to ensure the water table wouldn't get polluted? So when you talk about the compelling interest test protecting the free exercise of religion, it's not enough for government to have a compelling interest. They also have to show that they've tried to accommodate and that they could find the most narrow means possible to achieve that interest. In that particular case, the government refused to back down, refused to accommodate, litigated it all the way up to the U.S. Supreme Court, got reversed, it got sent back down to continue litigating. They continued to litigate up to the Minnesota Supreme Court, and then the Attorney General for the state of Minnesota changed. Some new lawyers came in and looked at the case, and they called us up and they said, you know what? We could have accommodated your clients from the very beginning. And they dropped the case and paid all the attorney's fees. And that's often how the free exercise of religion gets protected in the United States. You get kind of government bureaucrats who just refuse to try to think of a way to accommodate a religious person. The religious claimant is asking for some type of an accommodation. And if it ends up spilling off into a case, it's because you have that attitude of we simply will not accommodate. Generally speaking, when government tries to accommodate people in the free exercise of their religion, it works. and you don't have litigation, and you never hear about those cases because it just gets solved long before it ever turns into something that hits the news, okay? But that's how we tend to protect the free exercise of religion in the United States. That's half of religious freedom. The other half of religious freedom, the other half of the triumph of religious freedom, is what we call the right against establishment of religion, or an anti-establishment right. The establishment of religion is a state church. So we have a clause in our Constitution that says Congress shall make no law respecting an establishment of religion. That is not a religion that's been established, but an establishment of religion is an old term referring to a state church. We don't have a state church in our country. None of the states have state churches anymore. The last ones were kind of gotten rid of back in the 1830s. And what we say is under the Establishment Clause, government can't favor any one religion over another, right? You can think of this, how this is being litigated right now in some states, including in Texas. It's not being litigated, but I suspect it will be very soon. If state passes a law that says we're going to put the 10 Commandments up on every public school classroom, right? That starts to trigger a question. Does this violate the Establishment Clause? And I guarantee you there are law firms out there right now who have already drafted their complaints, and they're just waiting for the law to get passed so that they can file a lawsuit. And it'll trigger the question, does that violate the Establishment Clause in favoring one religion over another? And there will be lots of debates about this. One question will be, is it really favoring a religion? Is this in fact a religious text, or is it just trying to show some of the early foundations of Western law? That's what some people make the argument, that it's not just a religion. Others would say, no, this text favors any religions that believe in the 10 Commandments over all these other religions who don't, right? And the way we do this test in the United States right now, it's always in a state of flux. Again, not my fault. I blame the Supreme Court. And I don't really blame them either. It's hard to figure out what the rules should be for these things. But they're trying to interpret the Establishment Clause. What they have interpreted it to mean is, if you're thinking about a public school setting, government cannot coerce religion onto the students. You can't coerce people into engaging in religious practices or religious ceremonies or reading religious texts. And so you have to ask yourself then, does putting the 10 Commandments up on the wall in front of students where they have to see it every day in a classroom, does that coerce students who don't believe in the 10 Commandments to have to engage in some form of religious exercise? And if so, that would violate the Establishment Clause. That's how we do that. These two principles working together, protecting the free exercise of religion and ensuring that government is not favoring one religion over another, not coercing religion upon citizenry, has worked very, very well in our country to allow us to live alongside one another in relative peace. And when we have ignored these commands, because throughout our history we've had a very spotty track record of actually enforcing these things, what we've ended up with is violence and bloodshed, and even some religions almost being wiped out. And it's kind of been a spotty history, right? But when we're actually living up to our ideals, what we found is we're able to thrive alongside one another. That's the triumph of religious freedom. What is the controversy of religious freedom? Now, most people, when I talk about the controversy of religious freedom, would assume it has something to do with the big culture war issues, right? They'd assume it has something to do with LGBT plus rights or abortion rights, or that it's the latest thing in the news. That actually is not the controversy related to religious freedom in the United States. And I'll tell you, the big culture war cases, most people are surprised to hear this, but if you think about all the religious freedom cases percolating around the United States, and you start to figure out, well, what percentage of those has to do with abortion or LGBT rights? It's actually less than 2%. So that's not really the big controversy, but it's a symptom of what is the controversy. And the controversy relates to something that we refer to in the business as the Puritan mistake. Many of you have heard me speak before, probably heard me talk about this, but we like to say in the United States that the Puritans came here for religious freedom. And it's true, they did. That's not wrong. The problem with the Puritans was that they made a mistake. They were interested in religious freedom only for themselves and not for anybody else, right? So they literally passed a law in Massachusetts that said you can be a practicing Puritan or you can get out, right? Which is not really religious freedom for anyone other than the Puritans. So we refer to that as the Puritan mistake. Now, my mentor, a professor named Doug Laycock, is the scholar who labeled that mistake the Puritan mistake. And so one day he and I were walking along in a hallway. I said, Doug, why did you call it the Puritan mistake? As far as I can tell, every human group in the history of the world has been prone to commit the Puritan mistake. I mean, we see Christians do it to Muslims, and Muslims to Christians, and Christians to Jews, and Jews to Christians, and Muslims to Jews, and Jews to Muslims, and atheists to theists, and theists to atheists. I could go on and on and on. Buddhist to Hindu, and Hindu to Buddhist, and Hindu to Christian, Christian to Hindu. We just see everybody seems to be prone to committing the Puritan mistake. He said, I know, absolutely that's true. I just thought it was catchy, you know. Like, it's something that would resonate with people because we always say the Puritans came for religious freedom. It's like, fair enough. And it also doesn't sound very intelligent to call it the human mistake. Sounds like something George Costanza would come up with if you've watched Seinfeld, right? So Puritan mistake sounds catchy, sounds intellectual, but the reality is it's a very common human mistake to want to protect our own religious freedom and not that of other people. It's not unique to religious freedom, as we're learning. I think most people tend to value certain principles of law when it suits their tribe, their political tribe, and they tend to completely ignore them when it doesn't. And that's a real problem we have in a lot of areas of the law, but that is the source of the real controversy with religious freedom law. People tend to want the protections of the Free Exercise Clause when it's going to be protecting something that already aligns with their religious and moral views, and they do not want it if it's not aligning with their religious and moral views. I'll just give you one example of this on the Free Exercise Clause side of things. So take two types of cases. Is everyone familiar with the Masterpiece Cake Shop case that happened about 5-6 years ago now, right? It involved I see a lot of people nodding, but some people not. It involved a cake maker who could not make custom cakes for a same-sex wedding, okay? People on the political left, and he invoked the free exercise, protections for the free exercise of religion to protect himself when David and Charlie came in and they said they wanted a cake for their same-sex wedding. He said, guys, I'm happy to serve you in any way I can, but I can't do certain events and I can't do same-sex weddings. People on the political left were pounding the table. That is not what religious liberty law is for. We should not have religious liberty law for this. Religious liberty is a nightmare. We need to get rid of it, okay? And people on the right were screaming, this is exactly what religious liberty law is for. It's so important. It's one of our most fundamental freedoms, da, 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 da. Let's look at another type of case, immigration law. There are a lot of religious charities and churches and other groups in the United States who think it is absolutely a core part of their religious exercise to help immigrants who are in need. Sometimes they can be in need because they have nothing. Sometimes they can be in need because they're in the country illegally and they know government is going to be coming after them. So there's a long tradition going back centuries of churches offering what we call sanctuary to people who are being sought after by the government. And there's a long tradition in the United States of churches offering sanctuary to immigrants who are in the country and the government's trying to come after them. There's also a long and lengthy history in the United States and going long before of churches offering medical care and food and clothing to people who are immigrants. In that scenario, we have right-wing governments coming after these folks and right-wing people pounding the table and screaming, that's not what religious freedom is for. That's not should be protected. You know, this is a blasphemy to say that this is protection for the free exercise of religion. But I have news for people. Both the cake maker and the churches who are trying to help immigrants are using the exact same principles of law, and they're invoking the exact same rules. And both are challenging government to be able to get over the compelling interest test. And in both instances, what we see are people flipping positions based on whether they agree with the religious practice or exercise at issue, again and again and again. That's where the controversies arise. On the Establishment Clause side of it, we see the same thing. You'll get folks on the Christian right today when it comes to the Ten Commandments saying there's nothing wrong with having the Ten Commandments in public schools. This isn't really religion. What we're trying to teach is the history of Western thought and how it ties back to Christian norms and Judeo-Christian thinking, and this is really what's happening here. It's not really establishing a religion in schools. And of course, the political left is often pounding the table and screaming that this is obviously violating the Establishment Clause. You're obviously trying to push religion in public schools. And these two sides debate and debate and debate. When you talk about something like secular humanism, and folks on the political right say, well, wait a minute, our newfound friend is the Establishment Clause, and we want to invoke it to stop schools from pushing what we think is secular humanism, the religion of secular humanism in public schools. Suddenly the political left switches positions and says, oh, the Establishment Clause doesn't really have any teeth here. This actually isn't a religion in any form. How could you possibly argue it's religion? This is just a theory about how our society should be governed, akin to what you might think of as the development of Western liberal thought, right? Both sides are flipping their positions and making the exact same arguments. In other words, most people want the protections of the Free Exercise Clause and none of the burdens of the Establishment Clause, as long as those rules apply to them and to no one else with whom they disagree. Almost all the controversies related to religious freedom in the United States come from that behavior. It just manifests itself in different ways in different cases. So those are the controversies. Despite those controversies, by and large, I think religious freedom law has been a triumph in the United States, but that does not mean I'm suggesting it is by any means perfect. We have a lot of people and a lot of problems in the United States, but they are nowhere near as bad as what we see in many other countries. The arguments we are having here relate to something the Supreme Court said in 1943, when they were talking about a case in which school districts were trying to force the Jehovah's Witnesses to say the Pledge of Allegiance against their religion. Jehovah's Witnesses can pledge allegiance only to God, so the idea of pledging allegiance to a flag was something they could not do. They asked to be exempted out. The Supreme Court ruled against them every single time in a series of cases, and then the personnel on the court changed. 2 new justices were appointed, and several of the justices changed their minds. Can you imagine the fallout today in our Twitter world if 3 of the justices changed their minds on a case? Like, it would just be the biggest thing ever. But back then, there wasn't as many opportunities for everyone with a keyboard to spout their opinions, so it didn't result in as big a blow-up. But the Supreme Court changed its mind. It recalled all of the Jehovah's Witness cases and reversed itself in every single one of them and protected the Jehovah's Witnesses. And what it said was, invoking all the atrocities from Imperial Japan and Nazi Germany, it said, our aim in the United States is to avoid those ends by avoiding these beginnings. And that's really where we're at in the United States. We're trying to avoid all of these horrible genocidal ends happening in other parts of the world and in history by avoiding these beginnings in the United States by protecting religious freedom.